Yes, it's the 50th anniversary of Pink Floyd's Dark Side.
I was thinking about Jimi Hendrix Star Spangled Banner from Woodstock. Yeah. Yeah, I played that for my kids a few months ago. They were not impressed.
No?
Really?
Kind of hoping they would get the,
I need some more context.
yeah.
Right?
All right, welcome everybody. It is Thursday morning. We're going to work this morning on. We're gonna start with Damien, who's going to do a walkthrough, and then we'll have testimony from Julio Thompson. I believe it's first time in 3D for quite a long time, but Julio's here from the Attorney General's office just to talk about the discrimination parts of our statutes, what we've done, and how H-132 could fit into that. And then we're going to have a conversation later on this morning just to get I don't know, I don't have a most updated thing, I don't think, but it says housing. But we're going to talk with Ann Sosin from the Affordable Housing Coalition and Kathleen Burke from the State Housing Authority to get, we're going to hear an amendment on the floor about redirecting some funds to try to, through the Human Services Committee amendment to purchase housing and to provide services in anticipation of what may happen after subsidies and motel programs end in May and June. So we're going to get an update from State Housing Authority on all of that later on this morning. So we're starting to turn our Titanic over towards housing issues. It won't solely be housing issues for the next 6 weeks, but we're just laying some groundwork for our work in the next 6 weeks. So with that, I had asked Damien to come in the short history of this homeless Bill of Rights. Again, is 10 years old anyway. I believe Senator Ron Hinsdale offered the first version of this when she was still in the House. We've picked it up mostly. This committee's tried to pass it. The last time, again, prior to the pandemic, we were building momentum. We were working with a different attorney, and there were some issues that had come up in the 2019-2020 session that were considered constitutional problems. And once the pandemic hit, we had to drop work on this. I think it's appropriate, again, with what may be happening over the course of when we start to transition out of the hotel services and whatnot, just to think that if there's a lot of individuals who are experiencing homelessness, that they're not discriminated at in certain elements of our law. And so I'd asked Damien last fall to put together what he considered a constitutional version of the Homeless Bill of Rights and where it might fit in discrimination law. So I'm just teeing it up just to give us that little bit of history, and microphone is yours.
Great, thank you. Good to see everyone. For the record, Damien Leonard, Legislative Counsel. So the bill that you're going to see today is virtually identical to the one that was introduced last session, which I had worked on with Representative Kalaki to eliminate some of those constitutional questions and try to slow down some of the provisions to eliminate some of the problematic language. There are still some questions about some of the language in the Homeless Bill of Rights section. I'm not going to get too deeply into that today just because of time. But if the committee decides to move forward with this, we can discuss it in a little bit more detail. But in general, we've eliminated some of the most problematic or challenging language in here. and tried to pare it down. You'll notice that a big portion of the bill now is anti-discrimination language, which would provide a variety of protections that don't raise questions regarding equal protection or common benefits and so forth that my former colleague raised when he was staffing this bill. So I inherited this bill, I think about 3 years ago, maybe 4 years ago. And so this is kind of where we've moved to in the last couple of years. So let me pull the bill up. So the first section of the bill is a findings section. I'm not going to spend much time on that. Just going to say that it speaks for itself. So we can read those findings later if you decide to move forward with the bill and decide if they're findings the committee agrees with and wants to make.
Can you just take a minute? I think we've seen a couple of bills with findings in them and we'll see more. But can you just, when someone asks you to do findings or provides you with facts that kind of, can you just give us a quick, as an educational piece, just why someone might put findings into a bill and what the disposition is of findings if the bill passes?
Sure. So findings they often serve the purpose of helping future members of the public and attorneys and legislatures that look back at the actual bill rather than the statute to get an idea of what problem the legislature was trying to address. It can provide context for a court if they're trying to figure out legislative intent. And so in the court context and in the context of practitioners and future legislatures, it helps them understand how did they get from where they were to where they ended up and what was that problem. So if there's a word where we're not quite sure what it means or why it was put there, we can look to those findings in the same way we'd look to an intent section and say, what did they find were the problems that they were trying to address with this bill? So that is a main purpose of the findings section. It's important to note that if we do move the bill forward, you do want to read the findings section carefully because you're saying this is something that based on the testimony and materials we've reviewed as a committee, we're going to assert that the General Assembly finds this to be true. So sometimes when you have a bill introduced, the findings are proposed by the sponsor of the bill. The General Assembly may not agree with all of those findings. So that it is an important section if you move forward with the bill, because these are things where the General Assembly is saying that based on what we've heard, we find this to be true. And you may not agree with that. And so this is something where, because it's something for, basically it's forming your legislative history. And so this is something where you can clearly influence the legislative history in a way that the documents that usually form our legislative history don't. This is a clear statement from you as legislators to the future saying, this is the problem we're trying to address.
And we don't do that on every bill because a lot of the times the bills are changing within statute. This is creating a new section. Actually, we had a interview with some folks from Dartmouth yesterday from the Rockefeller Center, and they were talking about minimum wage. And I think back to our work on minimum wage, and at the beginning of the minimum wage section, there is an intent that says it is the intent or it is the policy of the state of Vermont that the minimum wage should allow, I'm paraphrasing, but should be allowed to have Vermonters be able to live and work, and have, not to say that they should have health benefits, but it was a statement of purpose of what the minimum wage was for. And I rarely see that in the work that we do, and we rarely do findings But that doesn't mean we don't.
Yeah, it's not a normal thing in the bills, or not. The majority of bills don't have findings in it. That said, we do have bills on particularly major issues or where there's new law. Findings or intent are common to describe what it is, what problem it is that you're trying to address. Another place you might see them, and one of the laws we'll address later, is, for example, the Public Accommodations Act. When we updated it to come into compliance with the Federal Americans with Disabilities Act, the legislature included an intent section that said it is the intent of the General Assembly that this law will be construed with respect to individuals with a disability as being consistent with the Americans with Disabilities Act. So even though our language didn't go into all the detail that the federal rulemaking around the ADA went to, we can look at that and say, okay, so they intended for this to be read consistently with Title II of the Americans with Disabilities Act that applies to governments. So we know when they say this, they meant that we read it in the context of that federal law, and it helps guide, again, the future to understand what was meant so that you don't have to argue over, well, what was the legislature trying to do? Sometimes it's very clear, like with the minimum wage, you can say the minimum wage is X dollars per hour. Sometimes, though, you're just using words that could have 2 or 3 different meanings depending on the context you read them in.
I recognizing that we're not picking apart this bill right now. I just want to put a pin in the fact that a homeless bill of rights is a little bit problematic. But maybe it should just be Bill of Rights because it lumps homeless as an adjective and leaves out. It lumps it all into a class of thing rather than people.
Yep, and retitling the bill is something you can do as part of your committee amendment if you decide to move it forward. And so that's just worth noting that you could also just title it an act relating to prohibiting discrimination against persons without homes.
Exactly.
And that,
or unhoused individuals.
we've heard the word vestige. And
Yeah.
this has been a vestige of,
Yep.
you know, where, how the language has changed for the better in 10 or 12 years.
Yeah.
Yep.
Yep.
All right, thank you for that.
Yep. Okay. Whoa. All right. I just skipped 6 pages. So that fast. All right. So the homeless Bill of Rights section here, again, the name of the section could change if you decide to move forward with this. This is a vestige of, as long as I've been working for the legislature, this section has been called this. So, and that's
When
what
it was originally passed nationally in a couple of different places, it was definitely called this, but again, that's the difference between now and when. And, you know, this has not taken the country by storm by any stretch of the meaning, but the communities that were able to pass something like this had referred to it this way. And certainly, again, fixing the language is totally appropriate.
Yep. So this would create a new right within Title I, which is our general provisions of law. And it would say, in addition to any other rights and protections provided under state and federal law, individuals have the right to use and move freely in public places, including public sidewalks, parks, transportation, and buildings, in the same manner as any other individual and without discrimination on the basis of the individual's housing status. They have a right to equal treatment by all state and municipal agencies without discrimination on the basis of the individual's housing status. Right to emergency medical care free from discrimination based on the individual's housing status. Right to vote, register to vote, and receive documentation necessary to prove identity for voting without discrimination based on housing status. and to a reasonable expectation of privacy in the individual's personal property without discrimination based on the individual's housing status. I want to just back up and note that numbers 1, 2, 3, and 4 are rights that already arguably exist. And the reasonable expectation of privacy also exists at common law, but there have been disputes around the country about how far that right extends for individuals without a home. So, and this relates to police search and seizure primarily in those cases. And there have been cases regarding whether, for example, you have a reasonable expectation of privacy in your home. But what if you're living under a tarp? Do you have a reasonable expectation of privacy for that? And there have been cases, and again, this is something we would need more time to go into, but there have been cases in other parts of the country where the courts have been asked to address that issue of whether someone, for example, has a reasonable expectation of privacy such that police would need to get a warrant to search in the tent or under the tarp or whatever shelter it is that they're living under, if they're not within the walls of a home. And so that's worth noting. This is essentially reiterating rights, and it's worth noting too that the reasonable expectation of privacy in the individual's personal property without discrimination based on housing status it is still open to interpretation by courts. What does that mean? And so there are some questions here. Julio can certainly flesh out some of these issues for you, and then we could spend more time on this if you move forward with the bill. Notwithstanding any provision of law or of a municipal charter to the contrary, no individual shall be subject to civil or criminal sanctions for soliciting, sharing, accepting, or offering food, drink, money, or other donations in a public place. This addresses basically it's targeted at anti-panhandling laws and ordinances. It's worth noting that some of the municipal charters in our state still have language dating back to the 1920s that is targeted at individuals who are unhoused or soliciting donations or asking for money in a public place, panhandling, as it's often called. And so this would basically say, notwithstanding any of those provisions of law or charters, rather than going back into every charter and trying to find that language, just saying all of that, you cannot civilly or criminally sanction someone for doing that in a public place.
So is that, if we wanted more information about some of those statutes, would we talk to Tucker?
It would either be Tucker or me, depending on workload. And certainly if we were going to draft amendments to those charters, we would work with Tucker, and it would have to go down to GovOps because all charters have to go down there, and that would be a more complicated issue. I worked with Tucker to develop this language here to simply override those charters. So the important thing to note, our state is a Dillon's rule state, which means that towns only have the authority that the state gives them. So if we say any provisions of charters that would criminally or civilly sanction someone for, requesting money or food, asking for money or food in a public place, are prohibited, then those provisions of the charters are overruled effectively. So.
Can you just say that last part one more time? So if
the state law basically, if we prohibit something that some charters would permit, and we prohibit it in state law, and we notwithstand any provisions of the charters to the contrary, we've overruled that because charters can only, a town only has the authority the state gives it. So if we take that authority away by state law and we say no charter can have a provision to the contrary, then
They have to abide by the state law versus their charter.
yes.
Thank you.
So, yeah, and we do the same thing where we give some towns, we specifically say, notwithstanding state law to the contrary, this town shall have the authority to do this. And so it goes both ways, but you have to have that express grant of authority. And then no law, rule, or ordinance shall adversely impact or penalize an individual based on housing status, provision of supports or services based on an individual's housing status, or the individual engaging in harmless activities that are associated with homelessness. Couple of things about this. One, so we've added the word adversely because previously this language had said impact or penalize. And certainly people are impacted by laws that provide public support based on housing status, and we don't want to prohibit those. But the other piece is, what is a harmless activity? And that's something that's up for discussion. And so that's one of those questions here. I just wanted to highlight that. We don't know what that means. And it certainly is open to interpretation in the future if you leave that in there.
Damien, start scrolling back
Yep.
for just the standard part about in a public space, these shall not be prohibited in a public space. And just to be clear, that means any sidewalk or street, even in front of a private business
Park.
or residence.
Yep. And I think there's some discussion about how far does public place extend? Does it extend to, into the lobby of a government building, for example? So there are some questions about some of these pieces here. What do we mean by public place? And what is other donations? Does that include, soliciting donations of prohibited substance? And these are questions that have been raised in the past. So I think these are all questions we're going to have to grapple with if the committee decides to move forward with Section 2 of this bill. The wording in this is very broad. I don't know how the other jurisdictions that have enacted similar language have interpreted it. I'd have to look back at my notes on that. And so it'll take a little bit more time, and we'll certainly want to speak with folks like Julio and others who may be able to provide some more insight into how they think Vermont's legal precedents would interact with language like this. But that, again, public place and other donations, throughout this section, we've taken out some of the most problematic language, but there are still pieces like that where the language is broad. And the question is it so broad that we're creating unintended consequences that you as a committee and as legislators don't want to create, or are you comfortable with the breadth of that language? And so that I think is the question for future hearings if you move this bill forward.
Thank you. Yeah, as you go forward, I would just suggest keeping the other donations and err on the side of in good faith, because what that would look like would be sleeping bag, clothing, toiletries, et cetera.
Right.
Other things that people would need to survive and stay alive. So, and medication other than illicit substances, right? So.
Yeah, and you can always
Right.
put in, language saying that other donations does not include,
Right, there you go.
solicitation of controlled substances.
Excellent. Thank you.
Yeah, that's for each of these when you see language like this that shows up in statute that just is not common, it will generate, again, the question that I think we're posing to almost anything we're gonna do in the next 6 weeks is, what are the intended consequences and then what are the unintended consequences?
Right.
So yes, exactly, being able to define what those things mean
Right.
will be important.
Okay, so subsection D provides a private right of action for an individual who's harmed by a violation. Yes.
I don't really understand, can you go back up for a second? How would a homeless individual file an action in the Superior Court?
They would seek out assistance from probably an attorney. They may be able to do it on their own. You would do it the same way any other individual would do it. You are allowed to file with the court to waive court fees if you can't afford them. So there is provision for that. But this is a question that you may want to address, is whether this is creating limitations on an individual's ability to protect their rights if you move this forward. But yeah, right now it would be, they would have to file the same way as anyone else, whether they could find an attorney or organization to represent them, or whether they filed pro se and then sought relief from fees and so forth if they couldn't afford them. So I think the situation will depend on the individual. Some individuals very well might be able to do this. Others may be very challenged by that, and that's a valid policy question.
Thank you.
And if they didn't have a private right of action, what would they have?
Well, so it really depends. You could provide for a complaint to a state agency. You could provide authority for a state entity to bring complaints on behalf of individuals who are harmed by this. For example, and I don't want to suggest out of turn that we load up the Attorney General's office with additional responsibilities, but for example, with employment discrimination, we provide that the Attorney General's office can receive complaints and then bring cases on behalf of individuals who are harmed. And some of the other provisions here would fall under public accommodations, where the individual could go to the Human Rights Commission, or employment discrimination, where the individual would go to the Civil Rights Unit of the Attorney General's office. And so the relief provided under this section is in addition to relief provided under any other provision of law. So that's reflecting that we're now providing additional protections. Housing status means the actual or perceived status of being homeless, being a homeless individual, or being a homeless person as defined in federal law. So that is what we mean when we say housing status, and we've defined it to be consistent with that federal statute, as well as using the more broadless or the more broad terms of homeless individual and homeless person. Place of public accommodation has the same meaning as in our Public Accommodations Act.
So if we decided that we needed to define any of those phrases earlier in the section, we could use this section to
Yep,
define.
you could use that subsection to provide additional context or definitions. Yeah, so we could say other donations does not include, illegal substances or something like that. And that would just narrow it down so that it could be clothing, sleeping bag, whatever it is, but not something that we would, potentially be creating a conflict with our criminal laws. So section 3 provides a definition of housing status for our Fair Housing and Public Accommodations Act. Section 4 prohibits discrimination under the Public Accommodations Act against an individual on the basis of housing status. So it makes housing status a protected class for purposes of public accommodations. Section 5 does the same thing for our fair housing law. So again, you couldn't refuse to sell real estate or rent an apartment to an individual because they were unhoused or because you believed they were unhoused. I'm scrolling down here just in the interest of time, but these are the broad protections here, where you can't, for example, advertise that homeless need not apply or represent to an individual that the apartment's not available because you think they're homeless, whether they are or not. In the same way that when you find out that an individual intends to occupy the apartment with one or more minor children, you can't say, "Oh, I'm sorry, we just filled the apartment." So they're providing the same protections as currently exist. Yep.
What is a blockbusting practice?
Blockbusting practice, thank you. So blockbusting practice is similar to, so essentially there are practices where you try to drive people away from or prevent people from moving into certain areas based on a protected class. So the most famous examples of this are instances where based on race, there were representations made or provisions put in agreements that would prohibit people based on race from moving into a neighborhood, or loans were not provided for people of a certain race. So for African Americans to move into certain neighborhoods, redlining, that sort of thing, all fall under that sort of blockbusting practice. So the idea is you're driving certain people out or clustering people of a certain protected class in a specific area to keep them out of other areas.
Doesn't the term blockbusting also get flipped by saying we want that people are selling their homes, they're being enticed to sell their homes, not in order to necessarily make it more enticing for people of color or other people who have been discriminated against to move in, but it would allow them to move in and say, "Oh, look, this is gonna break up your neighborhood." So there's an element of that. Again, the AG's office can explain.
Yeah, I should just be clear that I have sort of a limited knowledge base, and you have an expert in the room with you. So
yeah, we're strict because there's other discrimination questions to ask about as well, especially about what exempt or the protected classes are. So
yeah, and Boryang would be another good witness to have in on the Public Accommodations Act and Fair Housing, because her office enforces those provisions. So Section 6 gets us into 10 VSA 601, which relates to I think this is the Agency of Commerce and Community Development with respect to their housing programs. And so persons and families of low and moderate income means persons and families irrespective of these protected classes deemed by the agency to require the assistance needed here under their programs. I have to look back at that. I apologize, I'd forgotten that section was in there. But what we did throughout this bill was to basically try anywhere there was a government program that would help with housing or assistance to individuals who are unhoused. We added in housing status as a protected category to help protect individuals from discrimination in these programs. And then Section 7 is protections against employment discrimination based on housing status. So it protects an individual from being not hired or fired because the employer thinks or knows that they are unhoused.
And just the protected classes vary a lot. Housing, that's like 5 categories, and employment practice, it's about 10.
Yep, and there are categories that are different between them. For example, in housing, there are things like occupying with a minor child, which doesn't apply in employment. This is a vestige of our statutes. We've updated them at different times for different things. There are provisions in the employment laws that you don't necessarily find in the Public Accommodations Act or the Fair Housing Act. There are also terms that mean roughly the same thing, but we use different terms. And a lot of that was what was the term that was in use at the time the law was adopted. If you go through, there are more than a dozen anti-discrimination statutes, including our collective bargaining laws have anti-discrimination provisions in them. And the language is not identical across all of the statutes. So that could be another question that you may want to ask is, are there other consistencies you want to add, or is that another bill for another day?
I think I've shared this concern in the past, but I'll just bring it up. My question is, as someone who's worked in HR for most of my career, when we receive a new employee, they need to have an I-9. They need to have a physical address with that I-9, or a physical address or a PO box. That would be my concern with the wording here and how. So you, as an employer, you have, I think it's 72 hours for somebody who's new to submit an I-9 for them to continue to work. If you do not receive it by that time, you have to say, I can't let you work, or I can't let you start until I get that. So that would be my question and my concern on.
I think that would be, so I think that may be something that you would want to consider clarifying language on and hear testimony about. But certainly you could write in language saying, the prohibition against discrimination based on housing status shall not be construed to relieve an employer or make an employer liable for complying with federal law related to authorization to work and I could wordsmith the language there a little bit. But understanding that we can't simply say, well, our discrimination law says this, and now you don't have to comply with federal immigration law and working documentation requirements.
We had testimony from the Bankers Association.
Yeah.
Not the same thing, but similar to that they needed an exemption based on federal laws, federal banking law requiring X law.
And we've added language like that before on things like the requesting criminal history records or status of your criminal record status. There are industries where federal or state law requires you to do a criminal background check. And so prohibiting the employers from requesting information about that is counterproductive at that point. And so we can provide exemptions and fine tune.
Okay.
And then Section 8 is definitions for purposes of employment policy, and Section 9 relates to the general assistance program and other programs run through DCF. So we're just adding housing status again. And you'll notice again, it's a different list of protected classes for purposes of that law. And then section 10 is the effective date, which would be this July 1. That would likely have to change given that we're post crossover at this point. So.
Okay, so just as a bill walkthrough, thank you very much.
Welcome. Sorry, I ran into Julio's time there.
That's fine. He's been listening. So yeah, we can switch out and have Julio join us. Julio, introduce yourself, where you are in the AG's office. And again, the reason I asked Julio to come in, not just for this bill specifically, but just in general, we have a Senate bill that deals with some discrimination law. And I think this is just a useful primer for us to start to wrap our heads around what we're talking about when we talk about discrimination. And Julio, while I'm seeing the lists of protected classes, maybe we can start with, like, the federal government protects X number of people or classes of people, and Vermont is allowed to expand upon that. And I'll just leave it. And actually, let's just go around the circle, because again, it's the first time you've been here in a couple of dogs years. Representative Tom Stevens for Waterbury.
Claudia Lamont, Morristown, Elmore, Worcester, Woodbury, and the northern part of Stowe.
Joe Parsons, Newbury, Topsom, and Groton.
Ashley Barley, Fairfax, Georgia.
Caleb Elder, Addison 4 District.
Elizabeth Burrows, which is Windsor, or I represent Windsor 1, which is Heartland, West Windsor, and Windsor.
Larry Labor, Essex, Orleans, District 1.
Mary Howard, Rutland, District 6.
And I'm sorry.
Chestnut Tangerman, Rutland, Bennington District.
Okay. I'm Julio Thompson. I'm an assistant attorney general and director of the Civil Rights Unit in the Attorney General's office. I think I'll start a little bit about telling you what we do and what laws that we interact with. So one of our principal areas of work is in enforcing the Fair Employment Practices Act, or the acronym is FEPA. That I might use later on just to make things quicker. That's the law that is it's kind of a combination of different or a state mirror image of some federal laws that you may be familiar with, like Title VII deals with race discrimination, religion, national origin, sex, and as of 2020 from the Supreme Court, sexual orientation and gender identity. It also includes within it something that mirrors the Federal Equal Pay Act of 1963 that President Kennedy signed, that basically says even if the employer doesn't intend to discriminate, if people of different sexes are being paid differently for doing essentially the same work without some business justification, then they have to rectify that inequality. That's within FEPA. FEPA also has within it, it's the state law counterpart to the Americans with Disabilities Act. And actually before the Americans with Disability Act, the Rehabilitation Act, which is a post-Vietnam era law that was basically initially addressing disabled vets coming back from overseas. Vermont amended FEPA in 1987, so 4 years before we had the Americans with Disabilities Act. Vermont was already adding protections for folks with physical or mental disabilities. It also contains some things that aren't covered by federal law, and I'll talk about that in a little bit. So FEPA goes back to 1963, so Vermont beat Congress by a year enacting the law, but not always beating Congress. So Vermont didn't have equal pay in the FEPA statute until I believe it was, let's see, I might have written this down, 2002. It prohibited discrimination on the basis of sex if it was intentional, but didn't have equal pay protections. Sexual orientation was added to law in 1992. Gender identity was added in 2007. In 2000, the most recent amendments to FIPA in terms of protected categories were in 2018, July 1st, 2018. Crime victim status was added. And I'll talk a little bit about crime victim status and how that relates to the subject of this bill, because there is some overlap in that area. There are a number of ways in which Vermont law is more demanding than, say, Title VII or the Americans with Disabilities Act, and has been for a long time. One is the size of the employer that's covered. Under federal law, for most federal laws, it only covers employers with 15 or more employees. That's been true since 1964, hasn't changed. In the 70s, Congress passed a law that prohibits age discrimination, the Age Discrimination in Employment Act. That law only applies to employers with 20 or more employees. FIPA in Vermont, on the other hand, applies to employers with 1 or more employees. And that's been the case for more than a generation now. For all of the different protections that are covered, it's 1 or more employee. That's one key difference. So if there's a much broader suite of employment protections in Vermont than there is under federal law. Our office enforces FIPA, and we can do that by 2 principal means, really formal means. One is that we can, let me back up a second. Another way in which Vermont law is more demanding, more protective than federal laws, under the federal anti-discrimination laws, and it usually comes up in the context of either retaliation, like punishing someone or firing them if they complain or oppose discrimination. Under federal law, almost, I think without exception, there's no personal accountability. You can't be individually sued. So a supervisor under federal law who sexually assaults a subordinate can't be sued under Title VII. They might be sued for common law battery, but federal law doesn't hold anyone other than the employer liable if the employer is, knows of the conduct or condones it or encourages it. FIPA, on the other hand, does permit in certain cases individual liability for a predatory supervisor or a supervisor who is carrying out a kind of a personal vendetta against someone who complained against them. So that's another way. Sure.
Are you looking for Kathleen James?
No, I was looking for Kathleen Burke. She said she was in there.
Oh, she'll be here relatively soon.
Okay.
Thank you. Sorry. Thank you.
Thank you. Excuse me.
Sure. There are a couple of other protected categories in FIPA that federal law doesn't cover. I mentioned crime victim status is one. That's not covered by federal law in any way. Place of birth is something it may be unique to Vermont. It's not. There's already protections for your ancestry and your national origin, but Vermont back, I think it must have been in the late 1960s, included place of birth. So if you discriminated against someone because, as my aunt refers to me, I was born in Michigan as a flatlander. If I moved to Vermont and there's a discrimination against me because I wasn't born in Vermont, we see cases sometimes where people have Southern accents, for example. Vermont prohibits that as well. It's very uncommon that it comes to us, but it is something that's different about Vermont. This law also applies not just to employers, but also to employment agencies. So agencies that place employees, they can't discriminate in who they refer to employers. It also applies to labor unions. This is something often overlooked, I think, by the general public, is that sometimes we get complaints that individuals who are represented by a bargaining unit are not getting zealous advocacy from their union, and they allege that's because of their age, their race, and so forth. A final area where Vermont was a little bit different from federal law, more protective of workers, is that in age discrimination under federal law, it only applies to employees who are 40 years or older. So under federal law, technically, employers could fire someone who's 39 because they're going to turn 40 the next year, and federal law wouldn't cover it. Vermont law has long, in fact, since they included age discrimination, it covers individuals who are 18 and over. So again, it's the rare case, but an employer who doesn't hire someone or discriminates against someone because they're too young, which we sometimes get where someone might be in their 20s and viewed not eligible for something, not because they lack the skills or experience, but simply because they look young. They look too young for the job. It's uncommon, but it's something that Vermont protects as well. So that's kind of the coverage of FIPA that I think is important to know, and a little bit of the history. Our office, so we enforce it in two formal ways. One is that individuals can come to us and make a complaint of discrimination. They can do that by a toll-free number. We have online forms. We have paper questionnaires. Sometimes representatives and senators refer individuals to us. We also sometimes act upon things that we hear in the news that where no one came to us. Notably, our largest settlement in civil rights history came last summer, $1.6 million sexual harassment class action we brought with the federal EEOC. No one came to us. They came to the Boston office of the EEOC first. It was an employer that we were aware of from prior cases in sexual harassment. And so we intervened in that case and partnered with the federal authorities and came out with a 5-year consent decree, $1.6 million settlement that was distributed over breathtakingly large class of victims. We've identified 50 victims of one manager over a multi-year period. So we can be proactive. If we learn of something publicly, we have the authority, even if we don't have a complainant immediately that comes to us, we can nonetheless investigate employment practices. And in 2018, you also gave us the authority for sexual harassment to conduct sexual harassment audits. So I think I heard that you were an HR professional. Mm-hmm. So we work with HR professionals all the time, and the statute gives us the authority to do a random audit, to check in with HR professionals, see if their policies are up to date. And if we find anything that's maybe not quite up to date, the statute authorizes us to not take them to court, but do remedial kind of work, collaborative work, provide them models. And sometimes when we work with HR professionals, we find policies that are so good, we ask them, do you mind if we share this with other folks in terms of developing best practices? HR professionals have really strong communities, and they're part of our people because we're in the same business. We're just keeping businesses, productive, happy workers. So we have the authority to do investigations. That's not going to court. We have essentially subpoena power. So if we have evidence to believe that there might be a violation, we prepare what's called a charge of discrimination. It's signed under oath. Send it to the employer with a letter saying, "Welcome to the investigation. We're the AG's office. You have a month to respond to these allegations. If you have any other information, provide it." We also have a mediation program. So some employers right away may not have been aware. The leadership may not have been aware of the issues that are alleged in the complaint. We offer them a chance to mediate with the complainant. That's something we don't sit in on because we're the investigators. We can put the parties together with someone we contract with and see if they can work it out. General orientation, and I think this relates to this bill, the general orientation of our unit is we try to get, if we can get a broken or damaged employment relationship to work again, so that people who want to be, or there's a way for them to work together, they continue their career if that's what they want. That's something we do. And that's not always the case with private litigation, because it's not to disparage private litigation, but if someone's reinstated, they don't have an attorney who might be getting a portion of their fees from the settlement amount, that they can't get a portion of someone getting their job back. They can get a portion of a payment. So the incentives are a little bit different. And we try to, whenever we can, if there's any space at all, to sometimes it's reassignment, sometimes it's just a different position or more training and so forth. But that's what we'll do. We do our investigation under FIPA. We can go to court at any time, but we have this process and we try to stay out of court. It's very expensive for them. It's very time consuming for us. It's very disruptive because now once we're in court, now we're following the judge's schedule, not our own.
And so committee, I just want to pin this explanation of employment law as sort of a preface to the Senate bill that we're going to be dealing with which considers a concept of do not darken my door, which we won't go into now, but it is about exactly this particular situation where relationships get broken.
Yeah, I mean, it is, our mediation programs have a very high success rate in terms of resolving cases, usually before, the incentives are there to resolve early on both sides. One person may be out of income and facing mortgage payments or financial stressors. The other side, the employer businesses, particularly smaller businesses, are facing the prospect of increased legal fees and disruption of business. And so, so historically, we've had pretty good success with mediation. We do our investigation, and you know, even though we've decided to investigate, keep an open mind in our investigation. So we've got a statement under oath from a complainant, maybe some other evidence, but then we continue to look at the case with a clear eye for both sides to find out whether there's merit to the case or not. So it's not uncommon. In fact, I would say more times than not, we'll report back to the complainant that we weren't able to substantiate allegations of discrimination. I would say in a far smaller category of cases, but they exist, where we'll find that the evidence exonerates the employer. In a very rare subset of that, sometimes we uncover misconduct by the employee who came to us, and it's very rare. But the orientation of our unit for our investigators that we have, and the attorney general or assistant attorney general that works with me, is we want to verify everything, because people can pass lie detector tests and still have a recollection of events or a view of themselves on either way, which wouldn't match up with video footage. That's just human nature, and so we are trying to look, to get the best evidence we can. This is a hard pursuit for us, and it's hard for people to go to court because, unlike, say, proving bank robbery, you don't have to prove for bank robbery or theft the reason someone stole. You just have to prove they stole. For employment discrimination, if someone doesn't get a promotion, it's not enough to prove they didn't get the promotion. You got to show that it was for an unlawful purpose. And many times we have mixed motives, right? People have multiple overlapping motivations. And so we have to try to find evidence of that. And of course, it goes without saying, but I'm a lawyer, so I'm going to say it, which is that, people who act upon biases usually don't broadcast that, usually don't put it out there. Sometimes, we get a few a year where someone says, we just don't think someone your age can do the work, right? That happens every once in a while. But most of the time, we have to look for circumstantial evidence, and our investigators are very skilled in identifying that evidence. But sometimes it's just not there. Yeah.
Can you give me an idea of how many employment discrimination cases you might handle in a year?
Sure. So I would say when you say a case, I will distinguish between contacts for the public who are asking for help. We probably get between 800, maybe in a busier year, 1,000 requests for assistance. That might include employers who don't know if they're complying with the law or not. And then in terms of cases that we actually, open investigation, that's in the low hundreds. That's like 100 to 130, I would say. We probably have about 140 open investigations now. And in terms of litigation, that's very rare. The last year, that big EEOC joint venture we did, that was our only case in court.
It was handled in either a settlement or.
Yeah, absolutely. I have to say, and I don't know, I interact with my counterparts in New England. We're all part of the federal district, which is the New York district, which covers from Maine basically down to northern New Jersey, all the New England states. And I think we're more of a standout than the other states. They all investigate. They're not all AGs. They have commissions of human rights that deal with that. Our experience is that when we're done with our investigation, the non-court investigation, we put out a findings letter, and we tell them what we found and what the law is and where we think it is. It's not binding on the parties. It's often not admissible in court. We're just saying, this is what we found, and we think there either is or are not, statutory violations. And often it's a mixed bag. We couldn't substantiate this, but we found evidence of that. That happened. That's quite common. And our experience is that when we issue this letter, we call it a letter of determination. Typically, those cases, they settle when they do that. I think culturally, and this is like the starkest contrast might be Massachusetts, their Commission Against Discrimination. They issue findings all the time, and employers say, okay, fine, take us to court. In Vermont, if you get one of these letters from the Attorney General's office, very, very high level of resolution at some level. Or it can be when it's a mixed bag, where we find some violations and not others, we'll just say that. And then they have a letter from us identifying some violations, and then that person can then go to lawyers maybe who previously closed their door on them and say, hey, the AG said there's a violation of equal pay, but not retaliation. And that lawyer now knows that, this case has been pre-vetted versus one that just comes in over the transom. And so often they will take those cases and again, often settle. So in a more challenging cases or closer cases, our experience is that when we let the employer know we're about to file in court, there's usually another discussion and some resolution. They don't all resolve, and sometimes they get a private lawyer who goes to court. The lawyer might want to take all the claims and say, I think there is retaliation, even though the AG doesn't. So sometimes they don't want to invite us to their lawsuit because we might say, we'll take this legal claim, we'll join you on this legal claim, but we're not going to join you on this one because we don't think the evidence is there. And often a private attorney doesn't want us in the room. Because in settlement conferences, the judge is looking at us like, well, why aren't you in on this claim? And we would say the evidence we collected is we didn't think substantiated it. We're very transparent about that. So oftentimes we do not go to court. It's almost always done through these what we call administrative investigations. And even before we issue a findings letter, employers, and again, not to pick on the HR professional, but part of our part of our area of focus. In cases that are not going well for the employer, professionals know it. They sit in on an interview or they were asked about some evidence that we've uncovered, and they identify they may have a personnel problem that they were not aware of. And so there's often opportunities to resolve the case before we spend all of the resources to the full investigation. And we might approach the employer and say, do you want to have mediation now? Or are you interested in that? Or do you want to, if the parties are represented, lawyers can talk to each other about settlement. So we get a fair number of cases that may resolve. And again, it could be money, it could be training, it could be a letter of recommendation, or it could be reinstatement. Sort of depends what the parties want. But sometimes we get that as well. So we don't have a heavy litigation caseload, and we just don't go. I mean, literally, we could just go straight to court if we found evidence at the beginning. We could just go straight to court, but unless we needed something like an injunction, like an immediate court order to do something, which is rare, we won't do it. It's just too disruptive, and frankly, a court system takes too long. We do our investigations in under a year, oftentimes, whereas in civil court we could be going along three years.
So in something like this, and just want to be clear about the difference between discrimination and let's just leave it to employment law for a second. We're an at-will state, so you can be fired for no cause if the employer simply doesn't. The employer does not have to give you a cause. And this is what makes this conversation very fraught at times too, because our law isn't saying that you can't terminate someone in this case because they're not performing well. I mean, that's what we're trying to get to, is that their job performance might be the reason that they were let go, as opposed to, as you said before, no, Tom, I'm not going to hire you because I think you're too old for this job, which could be a slip of the tongue. It could be an internal, could be an internal bias. It could be whatever it is that becomes discriminatory. When I think about the homeless, this Bill of Rights law that we're dealing with, when we say they shall not discriminated against somebody who's in a public space, if they're acting unlawfully, they could be, the situation can be dealt with through that means, but they simply can't be told to move on because we know you're homeless or we think you're homeless. We don't want homeless people in front of our coffee shop. Unless they're saying that we don't want anybody in front of our coffee shop, or you can't be selling drugs in front of our, I mean, there's this weird, there's a very thin line here about what we're trying to protect versus what, you know, giving permission for people to act in a way that they can be judged.
Yeah, it's quite a good point. I think the higher resolution I would add to that when I talked about mixed motives is that an employer might have two reasons. So I'll give you an example. In the context of this bill, if the Fair Employment Practices Act were added to homeless status, suppose, for example, an employer had encountered in a span of a year 2 employees who were drinking at work. And one of them was a UVM student, head of their fraternity. And a few minutes before punching out, he had a cold one. And then the other person was someone known to the employer to be homeless, or to have been homeless. And fires the homeless person because he's drinking on the job, doesn't fire the college student. So we would look at that. We would look at that kind of case and identify our employers not being consistent in their business rules, because any employer can lawfully say, we're not going to allow you to drink on premises or come to work intoxicated. But if there's selective enforcement, and that's not just true for employment law. Think about going on I-89, right? What's the speed limit? Well, for some people it's 65 and other people it's 75. And so sometimes individuals feel like there's selective enforcement of a law. So the mere fact that you didn't meet a performance standard, could be most or all of the story, but it's equal employment opportunity. And so we might be looking at equal enforcement of what, the rules are. And that's kind of a circumstantial case. And if employers acting on an internal bias, what we view in all biases is internal, and what comes out is discrimination or discriminatory decisions. And so the fact that there's, maybe the employer's not aware of it, that's a tougher thing to prove for sure. So I could talk a little bit more about housing and how I think it might intersect with some of the things that are in the law, if that interests you. It's up to you.
We had a question from Representative Lamont, and I do want to, we're going to work till 10:25 and then take a 5-minute break and start with our next witnesses. So Representative Lamont.
Thank you. Very quick question. Does that law that you were just referring to and those requirements, do those apply to only to termination, or does that apply to promotions? Or say if someone's being overlooked for promotion chronically at a place of employment, and does that still apply if they're trying to prove discrimination in that capacity as well?
It's all terms and condition of employment. It's also applying for a job. So I heard earlier Damien refer to homeless need not apply. So sometimes we usually have interns looking at one ads in the summer. That's part of their job, is that, it says female bartender wanted. So we're like, well, what's that about? So that might be something that we look at, or we'll get tips from the public saying, college student wanted, that can be a code for a young person. And so that might be something that we look at, but it's all aspects of employment. That's job opportunity. So we sometimes encounter cases for our professionals where certain professionals, I'll just use one example. I'm not saying it's the representative example, but it could be new parents who might not get the more challenging, more rewarding assignments because there are assumptions about family care. And sometimes we encounter gender bias in the office where the employer knows that there's a parent that's living with them that needs some care. We encounter sometimes stereotypes that the female employee is assumed to be the one on call if someone has a fall or a need for a doctor, and therefore they may not get the same opportunities because the employer might assume that they're not always going to be there at my beck and call because they are, that they play that role in their family, whether or not it's true. So,
Is there a 1-minute answer to this question about
All right, I'm going to.
a casting agency or modeling agency saying, we are looking for a young Asian man for this? And obviously it's totally discriminatory, but it's a specific need.
It's a great question, and in fact, there is. Under federal law and state law, there's something called a bona fide occupational qualification. It's a pretty strict standard, but there are certain jobs for which, let's say, your gender or your sex, you might not be able to perform the job effectively if you didn't belong to one particular sex. So that could be someone working in the state hospital, for example, with a patient who's a victim of sexual assault. So that patient might have been sexually assaulted by a man. You probably would not have a male nurse dealing with that person being undressed. There have been cases, not in Vermont, because we haven't had cases involving our prisons this way, but other cases involving prison guards, where there would be cases where a female prison guard who may not have access to backup, may be in a particular wing with violent offenders who may be keying off of female guards, and therefore, again, it's very hard to prove or to establish. And the question is, can you effectively do the job if you didn't belong to a particular category? Not, and that's tougher. That's tougher for some categories or not, or others. So we take those on a case by case basis. But it's definitely true. There have been cases, not in Vermont. We would have to look at those cases, but there have been federal cases, for example, where it's I think the courts call it like an immersion experience restaurant. So it's like a taste of Mumbai, and it's an Indian restaurant, and they want all of the people to be from Mumbai. At an EEOC conference, I went to an Italian restaurant where all the waiters were from different regions of Italy, and they were trying to have you taste things from there. So they weren't just selling food, they were selling an immersion experience. And so different parts of the country have held like that. That makes it a little bit more authentic than you're selling more than the food. But if it were just, a hamburger stand, that would be hard to justify. So yeah, I probably went over a minute.
Thank you.
And actually, let's stop right there,
Okay.
because we'll have you back
Okay.
on 132. This was a really great introduction to discrimination law and how you view it in the AG's office. And we'll have you back for specifically on 132, and then we'll have you back again for S103. But
Yeah, I think it'll be smoother sailing for 103, having had this. So I do think
yeah, just to give us an understanding of what we're seeking to do with S103, but also, again, just to give us some vocabulary that we're working with and how it's solid law, but it's so interpretive. And I think our understanding of how that's going to work on all the levels we just identified today, how careful we have to be, or just how understanding before we put words out, because this is really a case where words matter. Discrimination is certainly a place where words matter. And so we'll have you back in.
Okay.
Relatively soon.
Okay.
And we'll also discuss at that point how this particular set of law translates to housing, right?
Yes, we're going to pick up, that'll be the next conversation specifically about H132. And then, because again, and then to go over, because one of the conversations in the past, and again, when I say things in the past, doesn't mean we can't have the conversation in the now. But one of the conversations we had in the past about what we've been calling the Homeless Bill of Rights is that the question is it necessary? Will be a question for us if we change the law in the second half of the bill that we read through, where we're changing it in all these other anti-discrimination sections.
So I think we can talk quite competently about the employment law. We don't enforce the housing or public accommodations law. So that's something that I think you'll want to hear from the Human Rights Commission on. And I think as the bill progresses, another area, I wasn't prepared to talk about it today because I wasn't sure it would be a topic of interest in terms of, I mean, there were some questions about so-called panhandling laws. So I, in my capacity in civil rights, one of the areas I work in is the area of First Amendment. So I testify on First Amendment implications for a number of laws. And so there, you know, if you get to that point, I could probably provide some context about what the U.S. Supreme Court and the Second Circuit have said about different types of laws and what are permissible and what are not permissible. And finally, the last thing I want to say is talk about blockbusting. So blockbusting, at least originally, was a practice where realtors wanted to sell house or wanted to purchase houses under market value would they would assess an area that was predominantly white, historically all white, and then they would find a middle-class black family to put in the middle of the block. The hope or the aim was to provoke white flight, so that neighbors who didn't want they would stoke fears that black people are coming to your neighborhood, and so the white families would sell their houses under market value, which the realtors would then purchase and sell for a higher profit. That's what blockbusting. That's the original meaning of the term blockbusting. People are familiar with the term white flight from the middle of last century, and that's really what the practice was, a very cynical, evil practice.
Wow. Thank you so much.
Sure.
Committee, let's take 5 minutes to just shoot that off, and then we'll get an update on the homelessness situation that we